Subcommittee on Civil Liberties, Civil Rights, and the Constitution is called to order. Without objection, the chair will have the right to call a recess at any time. I welcome everyone to today's hearing on the need to enhance the Voting Rights Act, particularly the areas of preliminary injunctions, bail-in coverage, election observers, and notice. Before we continue, I would like to remind members that we have established an email address and distribution list dedicated to circulating email exhibits, motions, and other written materials that members might want to offer as part of today's hearing. If you'd like to submit those materials, please send them to Judiciary Docs, DOCS, all one word, at mail.house.gov. We will distribute them to members and staff as quickly as possible. Finally, I ask all members and witnesses, in person or remotely, to mute their mic, as well as prevent feedback and technical issues. You, of course, may unmute yourself anytime you seek recognition. And now I'll recognize myself for my opening statement. Throughout his historic life, our former colleague, our former friend, my dear friend and hero, the late John Lewis, often said that the right to vote is the most powerful nonviolent tool we have in a democracy. If we are ever to actualize the true meaning of equality, effective measures such as the Voting Rights Act are still necessary requirements of democracy. John Lewis almost gave his life for the right to vote, as did others. We need to make sure that as legislators, we can do the simple things, and that's pass a Voting Rights Act and move forward. Under my chairmanship, the subcommittee has devoted considerable time and resources to take his call, the call of John Lewis, to defend the right to vote. And we need to act. Both parties need to act. This is a bipartisan issue. As we approach the first anniversary of John's passing, we in Congress must rededicate ourselves to protecting this most fundamental right at a time when it is again under threat, including in his home state of Georgia. And again, I would ask everybody, Democrat or Republican, Independent, John Lewis almost gave his life, was there at the signing of the Voting Rights Act. We need to pass the John R. Lewis Voting Rights Act in his honor and in regard for our oath and our duties as defenders of the Constitution. Earlier this year, Georgia enacted a sweeping voter suppression law, SB 202, with little transparency or normal legislative process. SB 202 imposes unnecessary and arbitrary burdens on certain election practices that are disproportionately used by Black voters and other voters of color, including voter ID requirements for absentee ballots and criminal penalties for groups that provide voter assistance. It is for this reason the Department of Justice filed a lawsuit last Friday to challenge that law's legality under the Constitution and under the Voting Rights Act that remains. While much of the subcommittee's work over the last few years has been geared toward revitalizing the Voting Rights Act pre-clearance provision in the wake of the Supreme Court's 2013 decision in Shelby v. Holder, we will focus today on other provisions of the Act that, while not a substitute for pre-clearance, are nonetheless important supplements to it and remain viable, although may be in need of some additional strength. One consequence of the Shelby County decision is in the absence of pre-clearance, both the Justice Department and private parties have been forced to bring legal challenges to discriminatory voting laws pursuant to Section 2 of the Voting Rights Act. Section 2 prohibits any state or political subdivision from enacting any, quote, voting qualification or prerequisite to voting or standard practice or procedure, which results in a denial or abridgment of right of any citizen of the United States to vote on account of their race or color, or on account of membership in a language minority group. As many witnesses have told us already, Section 2 litigation is expensive, time-consuming, and resource-intensive to the point that many plaintiffs with meritorious claims of voting discrimination may be dissuaded from even pursuing a lawsuit. The greatest concern with exclusive reliance on Section 2 litigation, which is all we have left after Shelby, is it's difficult, if not impossible, to stop the harm to voters that a discriminatory voting measure can inflict before such a measure is implemented. In theory, the Department of Justice can file a Section 2 lawsuit, seek a preliminary injunction to prevent discriminatory voting measures from being implemented. But given the complexity and time-consuming nature of Section 2 cases, it'd be hard for anyone seeking a preliminary injunction to obtain one under the present standard. Compounding this difficulty is the fact that courts are reluctant to grant preliminary injunctions in the period shortly before an election, based in part on the Supreme Court's admonition in Purcell versus Gonzalez, that courts should be wary of enjoining electoral rules that when there is inadequate time to resolve factual disputes before the election proceeds. The result in many cases is that minority voters may be disenfranchised by a voting measure that a court may ultimately conclude is discriminatory, but which would be in effect during one or more elections. In short, in the absence of a preliminary injunction, minority voters could be irrevocably harmed by discrimination, as would democracy, and there would be no other after-the-fact remedy for that harm. H.R. 4, the John Lewis Voting Rights Advancement Act from the 116th Congress would partly address this situation by amending the preliminary injunction standard applicable to voting rights cases to ensure that plaintiffs can obtain sensitive injunction where they raise a serious question as to the merits of their claim. While no substitute for preclearance, this proposal would help mitigate some of the risk to harm to minority voters posed by the absence of preclearance. A less discussed consequence of the Shelby decision is that it undermined the ability of the Justice Department and the general public to get notice of any changes to voting laws, policies, or procedures. In addition to being an effective enforcement mechanism, preclearance can function as an effective notice regime. As Professor Justin Levitt testified before the subcommittee in 2019, without a preclearance system, it will be more difficult to learn about and draw appropriate attention to discriminatory policies so that few entities with sufficient resources and expertise know where to litigate in the first place. And I guess I slipped over the script there because I've said the word line. And that was probably because of why I didn't sleep well last night. The lines are being redrawn as we speak. And the lines are being drawn in gerrymandered fashions throughout this country, but through a slip that I was privy to hear being done in Tennessee and in my district in such ways as to destroy the integrity of the city of Memphis, the county of Shelby, and district geographic lines, done to, in essence, take certain people out of this district. We should have notice of that and an opportunity to prepare, but we won't. The need for such notice and transparency changes in voting measures is particularly acute at the local level where such changes can be otherwise hard to detect. These include last-minute changes to election procedures, changes in polling place resources, and changes in district lines, which are going on as we speak. H.R. 4 requires state and local jurisdictions to publicize types of changes in voting practices and provide other types of information that may be relevant to assessing potential violations of the Voting Rights Act. This type of reporting requirement entails a relatively low burden on states and plainly bears a logical relation to facilitating Congress' ability to ensure proper function of the law. H.R. 4 offered other enhancements to the Voting Rights Act, including making it easier for courts to bail in jurisdictions to preclearance on a case-by-case basis, and also making it easier for courts and the Department of Justice to authorize federal election observers. These proposals, like those concerning preliminary injunctions and notice, are simple and common sense fixes that we ought to support. We should think of America, we should think of democracy, and we should think of the Constitution before we think of politics. I thank our witnesses for the participation in today's hearing and look forward to their testimony. Now, my pleasure to recognize the ranking member of the subcommittee, the gentleman from Louisiana, Mr. Johnson, for his opening statement.
Thank you, Mr. Chairman. This is the subcommittee's third hearing in the last 3 months regarding the Voting Rights Act. I understand the focus of today's hearing will be on preliminary injunctions and bail-in coverage and election observers and notice requirements. I presume my colleagues on the other side of the aisle will focus on these provisions in the context of H.R. 4, the Voting Rights Advancement Act. Unfortunately, just like H.R. 1, the misleadingly named For the People Act, H.R. 4 seeks to federalize elections. This is about federal control, a federal takeover of an area that has always been within the jurisdiction of the states. That would be contrary to the Constitution's explicit mandate that it is the state legislatures that administer our elections. H.R. 4 intends to reinstate the pre-clearance requirement that was struck down by the Supreme Court in 2013 as unconstitutional. It was for a good reason, and it was well explained by the court. This bill seeks to lower the triggering mechanism, which subjects jurisdictions to pre-approval from the Department of Justice at the federal level before they can make changes to any of their election procedures. Additionally, the legislation puts in place so-called practice-based clearance requirements. These would require all state legislatures and political subdivisions to seek permission from the federal government before they can change certain laws and policies. This is regardless of whether the jurisdiction has a history of any kind of discrimination or is covered under the new formula. And this legislation is just another example of a politically motivated power grab to enable partisan federal bureaucrats to control our state election laws. Voting is a fundamental, constitutionally protected right in this country, and the 15th Amendment requires states to ensure voting is accessible and available to every American. States also need to administer elections that are free from fraud and administrative errors. The COVID-19 pandemic, as we all know, presented new challenges for the 2020 election, and it drastically altered how states administer their elections. Many of these changes were unconstitutionally implemented via executive or court order, completely bypassing state legislatures, as is required in the text of the Constitution itself. As a result of the 2020 election and the numerous errors that resulted, many state legislatures have duly enacted or proposed changes to their state election laws. They want to clean this up and make sure that we don't have the controversies that we had in the last cycle. These changes largely seek to enhance election integrity and increase the public's waning confidence in our election processes. It is outrageous to see the federal government fighting back against these common sense reforms, such as the latest lawsuit filed by the Department of Justice against Georgia over its election law. It appears to millions of Americans that we are weaponizing the DOJ and trampling upon essential states' rights and the will of the people enacted through their duly elected representatives. Let me be clear. Republicans want every legally cast ballot to count, but the only way to give legal votes the weight they deserve is to close the door to fraud and illegally cast ballots. I hope today we can have a productive conversation about voting rights and how we could best safeguard the ability of all eligible Americans to vote. I can tell you right now, the answer is not to go backwards and reinstate provisions of the Voting Rights Act that have already been deemed by the court to be unconstitutional. Our extraordinary republic has endured for nearly 2.5 centuries, based in large part on the understanding that our elections will be fair and free and secure. Our Constitution and our institutions will endure, but only if we support and defend them. That has never been more important than it is today, and I think we can all agree on that. I thank our witnesses for appearing today, and I look forward to your testimony. And Mr. Chairman, I yield back. I think you're on mute, Mr. Chairman.
Thank you. That was. Does Mr. Nadler, the chairman of the full committee, is he present to give a statement, or does he have a statement he wants to submit?
I'm here.
Thank you. The chairman of the full committee, Mr. Nadler, is recognized for 5 minutes.
Thank you, Mr. Chairman. I appreciate you holding today's hearing to consider whether and how Congress might strengthen provisions of the Voting Rights Act other than its Section 5 preclearance provision. This subcommittee has rightfully spent much of its time since last Congress devoted to voting rights, specifically examining the proliferation of racially discriminatory voting barriers following the Supreme Court's decision in Shelby County versus Holder. During these hearings, we have heard significant testimony urging Congress to restore to full effectiveness the VRA's preclearance provision, which was rendered effectively void after Shelby County. Yet, while Section 5 preclearance is perhaps the VRA's most important enforcement tool, and revitalizing this provision is the most effective remedy to the ongoing widespread and persistent voter discrimination throughout the country. In the 8 years since preclearance was effectively gutted, we have seen the critical role that other Voting Rights Act provisions also play in remedying the plague of voter discrimination. Our experience since Shelby County has also taught us, however, that each of these provisions has shortcomings that can be improved upon. First among these is litigation under Section 2 of the Act, which prohibits voting practices or procedures that discriminate on the basis of race, color, or membership in certain language minority groups. While an important pillar of the VRA, Section 2 litigation is not a substitute for a working preclearance regime. One weakness of Section 2 is the difficulty plaintiffs face in obtaining preliminary injunctive relief to prevent the challenged voting law procedure from going into effect while litigation is pending. We will hear from our witnesses today that this often results in the effective disenfranchisement of minority voters because a challenged law that ultimately is found to be discriminatory remains in effect for the duration of lengthy litigation. There are other provisions that Congress should also consider revisiting. To begin with, we should look at Section 3C, the VRA's bail-in provision. Congress understood that the VRA's Section 5 preclearance provision could be under-inclusive, and therefore it included Section 3C to address situations in which preclearance may be justified, but a jurisdiction might not meet the requirements for Section 5 preclearance coverage. In such cases, Section 3C allows courts to retain the authority to supervise further voting changes in jurisdictions where the court has found that the jurisdiction in question violated the 14th or 15th Amendments. If a jurisdiction is bailed into preclearance, it must submit any changes to its voting procedures for approval either to the court or to DOJ, with the court determining both the scope and duration of such a preclearance requirement. Despite its availability, however, courts have rarely invoked Section 3C as a remedy. This is because plaintiffs face a high burden in proving a constitutional violation, which requires a showing of intentional discrimination. Even where there is evidence that officials acted with discriminatory intent, courts have shown reluctance to find that such officials engaged in purposeful discrimination. Moreover, since the Shelby County decision, some courts have suggested that not all violations of the 14th and 15th Amendments support Section 3C bail-in coverage. Bail-in coverage can be an important enforcement tool, but given how reluctant federal courts are to invoke Section 3C, Congress should consider whether the violations for which this relief are available are simply too limited to carry out this provision's purpose effectively. Another area that we should examine is the appointment of federal election observers. Section 8 of the VRA permits the Attorney General to assign federal observers to jurisdictions covered by Section 5 preclearance. Likewise, Section 3A allows federal courts to assign federal observers in appropriate circumstances. Federal observers can report voting irregularities, which can lead the Justice Department to negotiate with the jurisdiction to improve voting practices without resort to legal action. Observers also help gather evidence if legal action is required, and their mere presence can help deter voter discrimination. An oft-overlooked side effect of the Shelby County decision, however, is that it significantly reduced the number of federal observer appointments. DOJ officials have interpreted Shelby County as prohibiting it from certifying jurisdictions for federal observer coverage because the formula used to identify such potential jurisdictions was declared unconstitutional. As a result, the number of federal observers assigned since Shelby County has dropped precipitously. To compensate for the lack of full-fledged observers, DOJ has relied on so-called monitors to ensure that jurisdictions with a history of discrimination conduct the election process in a fair manner. Unfortunately, these monitors do not possess the same authority as a federal election observer, and as such, jurisdictions are not required to provide them the same level of access to the voting process as observers, limiting their effectiveness. As we consider revitalizing the VRA, Congress should consider how to strengthen the ability of the Justice Department and federal courts to send election observers whenever and wherever justified. In the 8 years since Shelby County, we have seen how indispensable the Voting Rights Act is in ensuring that all Americans enjoy the right to vote, free from discrimination. Section 5 preclearance remains the most potent remedy for widespread and persistent voter discrimination. And no matter how much Congress strengthens other enforcement provisions of the VRA, even these enhanced provisions alone can never be a complete substitute for Section 5 preclearance. Yet Congress should not pass up the opportunity to consider revitalizing and improving the VRA's other provisions, which operate in support of or to cover any gaps left by Section 5. I thank Chairman Cohen for holding today's hearing, and I look forward to the testimony of our witnesses, and I yield back the balance of my time.
Thank you, Mr. Nadler. It's my understanding that there's not a statement from the ranking member who ordinarily would be provided that opportunity at this point. So we will go on to our witnesses. We welcome our witnesses and thank them for participating in today's hearing. I will now introduce the witnesses before they testify and give their oral or written testimony. All of your written statements be entered into the record in its entirety. I ask you to summarize your testimony to 5 minutes. To help you stay within that 5 minutes, our witnesses, there's a timing light on your table if you're there in person, and green means you're okay. It's within the first 4 minutes. Yellow means you're entering the last minute, and red means you need to wrap up or have wrapped up. For witnesses testifying remotely, there's a timer in the Zoom view that should be visible at the bottom of your screen, or if you're in full view as I am, on the left-hand side. And it'll give you how much time you have remaining. Before proceeding with the testimony, I'd like to remind all of your witnesses that all the witnesses, you have a legal obligation to provide truthful testimony and answers to the subcommittee. Any false statement can be subject to prosecution under Section 1001 of Title 18 in the United States Code. Our first witness is Sophia Lynn Lakin. Ms. Lakin is the Deputy Director of the American Civil Liberties Union Voting Rights Project and assists in the planning, strategy, and supervision of the ACLU's voting rights litigation nationwide. She has an active docket protecting voting rights and combating voter suppression across the country. Unfortunately, it's very active, and has led or worked on successful challenges to discriminatory voting laws in Georgia, Indiana, Kansas, Missouri, North Carolina, Pennsylvania, Texas, and Virginia. Currently, she's the ACLU's lead counsel in 6th District of the AME, African Methodist Episcopal Church, versus Kemp, a federal lawsuit challenging multiple provisions of Georgia's sweeping new voter suppression law, SB 202. Before joining the ACLU, Ms. Lakin clerked for the Honorable Raymond J. Lower, Jr. of the U.S. Court of Appeals for the 2nd District, and the Honorable Carol Bagley Amon of the U.S. District Court for the Eastern District of New York. She received her JD degree from Stanford Law School, a school that has a baseball team as part of its undergraduate group that lost to Vanderbilt in the College World Series. Vanderbilt is playing for the championship. Stanford is not. She received her MS in Management, Science, and Engineering and her BA in Political Science from that same Stanford University. We thank you for the wild pitch that put Vanderbilt in the College World Series. Ms. Lakin, you are now recognized for 5 minutes.
Chair Cohen, Chair Nadler, Ranking Member Johnson, and members of the committee and subcommittee, thank you for the opportunity to testify today. My name is Sophia Lakin, and I'm the Deputy Director of the ACLU's Voting Rights Project. The VRA is one of the most successful pieces of civil rights legislation in our history. But in 2013, the Supreme Court gutted the VRA's most powerful provision, the Section 5 preclearance system, which enabled the federal government to block proposed discriminatory voting restrictions in places with the worst records of discrimination before they could be implemented. As the late Justice Ruth Bader Ginsburg famously warned in her dissent in Shelby, gutting of the preclearance provision was like, quote, throwing away your umbrella in a rainstorm. And sure enough, the downpour came with a wave of discriminatory voting laws. The ACLU has been on the front lines. We've opened more than 80 new voting rights investigations and cases since the decision. Some of our recent and ongoing cases include 6th District of AME Church, which with other civil rights group, we're challenging SB 202, which has been referenced, Georgia's latest effort to restrict the voting rights of Black and Brown voters, and NAACP versus McCrory, where we and others successfully challenged a sweeping North Carolina bill that sought to eliminate means of participation used by more than 1 million voters in the 2012 presidential election. But this kind of case-by-case litigation, while important and necessary, is simply insufficient to protect voting rights. Voting rights litigation is incredibly expensive, complex, and time-consuming. Their costs can easily run in the 6 figures. These cases also take multiple years to litigate, which means many elections involving hundreds of elected officials can take place under regimes that are later found to be racially discriminatory. An irrevocable taint on our democracy that we have unfortunately seen play out in states like North Carolina and Texas. I detail several other examples in my written testimony. The Supreme Court in Shelby based its ruling in part on the assumption that preliminary relief would be available before an election to guard against this problem. But the theoretical availability of such relief has also proven to be inadequate. The current standard for obtaining a preliminary injunction makes it difficult to obtain. My written testimony describes 15 cases in which voting rights plaintiffs who ultimately succeeded were unable to obtain preliminary relief while their cases were pending, with numerous elections taking place, millions of voters casting ballots, and hundreds of elected officials taking office under regimes courts ultimately find are discriminatory or are abandoned. The problem has only worsened due to the expansion of the so-called Purcell principle. This is the idea that courts should be cautious changing election rules if an election is imminent. But what began as a common sense warning to consider potential voter confusion and administrative burdens now operates effectively as a bright line rule against intervening as an election draws near. The use of Purcell to stymie voting rights plaintiffs has skyrocketed in recent years, from 6 in 2012 to 11 in 2016 to 58 times in 2020. All too frequently, this rule is wielded inconsistently in one direction only, to undermine efforts to ensure that discriminatory practices are blocked before they can taint an election. The North Carolina case I mentioned is illustrative. The law we challenged eliminated 1 week of early voting, same day and pre-registration, and the counting of ballots cast out of precinct. The law also banned the use of many forms of government-issued photo IDs to vote, including student and public assistance IDs. The Fourth Circuit struck the law down as unconstitutional, targeting Black voters, quote, with almost surgical precision. But the case cost $5.9 million and took 34 months to litigate. In the meantime, the 2014 general election went forward under the provisions of the new law, with 188 federal and state officers elected, including 13 congressional seats. We did everything to prevent this from happening. We litigated on an expedited timeline and sought a preliminary injunction before the 2014 midterms, which the Fourth Circuit granted. But the Supreme Court stayed that ruling because of Purcell, leaving the discriminatory regime in place for the 2014 election. The law has since been struck down, but it's impossible now to compensate Black voters of North Carolina for that gross injustice. And that's just one example. My written testimony details several others. Racial discrimination in voting continues to threaten the health of our democracy, and we lack adequate tools to combat that threat. Stronger voting rights protections are absolutely critical. Thank you.
Thank you, Ms. Lakin, for your work and your testimony, and I hope you're not a diehard baseball fan. Next, I would like to recognize Ms. Helen Butler. Ms. Butler is Executive Director of the Georgia Coalition for the People's Agenda. In that role, she leads an advocacy organization founded by the late, great Reverend Dr. Joseph E. Lowry, and comprised of representatives from human rights, civil rights, environmental, labor, women, young professionals, youth, elected officials, peace and justice groups throughout Georgia and other southeastern states. She leads initiatives that increase citizen participation in the governance of their communities and areas, including education, criminal and juvenile justice reform, protecting the right to vote, and economic development. Ms. Butler, you are recognized for 5 minutes.
Good morning, Chairman Nadler, Chairman Cohen, and members of the subcommittee. Of course, I'm Helen Butler, and the People's Agenda is a nonpartisan, nonprofit organization founded by Dr. Lowry. It has always been dedicated to fighting for the voting rights of Georgia's citizens through public education, training, advocacy, and litigation. In the wake of the Supreme Court's 2013 decision in Shelby County v. Holder, and due to the lack of the pre-clearance process, we have been forced to spend even more time and resources fighting discriminatory voting laws, policies, and practices at the state and local levels. Today, I will provide you with some examples of barriers to the ballot faced by voters of color in Georgia since that decision, and the loss of Section 5 pre-clearance. How my organization and others have been forced to divert significant time and resources to monitoring and responding to voting changes, and why we need to restore the full protections of the Voting Rights Act, including the pre-clearance and notice provisions, by enacting the John Lewis Voting Rights Advancement Act. I have submitted a full written statement to the subcommittee for your consideration. In the last 2 decades, the Georgia electorate has undergone significant demographic changes, with the percentage of Black voters and other voters of color increasing. Instead of welcoming the increasing diversity of Georgia's electorate and respecting the votes cast by Black voters and other voters of color, Georgia's conservative legislators' immediate response to the political changes has been the introduction of a host of voter suppression bills in both the Georgia House and Senate, especially during the 2021 legislative session. The bills were rushed through committees in the House and Senate, often with little or no time for ranking members on the committees, much less the general public, to have an opportunity to review the draft or final versions of the bills before they were voted upon. This process, led by the majority party with virtually no transparency, culminated in the passage of an omnibus voter suppression bill, Senate Bill 202. With almost surgical precision, SB 202 targets the methods of voting increasingly being used by Georgia's Black voters and voters of color, with arbitrary and unnecessarily burdensome requirements that will disenfranchise voters and potentially expose nonprofit civic engagement organizations such as the People's Agenda to fines and criminal penalties. The majority party also led the passage of legislation reconstituting a number of Georgia's county boards of elections, including Morgan County, where I live and served on that board since 2010, as well as in Troup County and Spalding County and others. I believe that the legislature targeted these boards of elections because of our opposition to efforts to suppress the Black vote by conservatives on our boards. Since Shelby County decision, conservatives in the Georgia legislature introduced 2 mid-decade redistricting bills, which sought to reduce the percentage of the Black population in Republican-held districts that were starting to become more competitive. Given the history of unconstitutional racial gerrymandering by the Georgia General Assembly, the People's Agenda is concerned about the potential for a repeat of these tactics during our current redistricting cycle in Georgia, particularly in the absence of pre-clearance of the plans by the Department of Justice. In the aftermath of the Shelby County decision, many of Georgia's county boards of election also proposed or took actions to close, consolidate, or move polling locations, oftentimes in areas primarily serving voters of color and in underrepresented communities. In fact, the Dougherty County Board of Elections recently is considering closing 10 of its 28 polling locations, allegedly due to low turnout in the 2020 election cycle in spite of the pandemic. In the wake of these new attacks on voting rights of Black voters and other voters of colors in Georgia, the People's Agenda is extremely concerned about this landscape, and we believe that Congress must pass legislation to restore full protections of the Voting Rights Act, including the John Lewis Voting Rights Advancement Act. Thank you for your time and your consideration.
You're on mute.
Thank you, sir. Our third witness is Maureen Warden. Ms. Warden is litigation counsel at the Public Interest Legal Foundation, which she joined in 2021. Previously, she spent 20 years as an attorney in the voting section of the Civil Rights Division of the U.S. Department of Justice, where she worked on hundreds of elections, voting, and redistricting matters. During the Trump administration, she served as senior counsel to the Assistant Attorney General for Civil Rights, where she was responsible for the voting section. Ms. Warden received her JD from St. Mary's University School of Law and her BS in criminal justice from Seton Hall University. Ms. Warden, you're recognized for 5 minutes.
Good morning, Mr. Chairman, ranking members, and members of the subcommittee. Thank you for your invitation to speak with you today. As indicated, I'm an attorney with the Public Interest Legal Foundation, a nonpartisan charity devoted to promoting election integrity and preserving the constitutional mandate that allows states to administer their own elections. I've been an attorney for approximately 35 years, 20 of which I served in the voting section. 20 years at DOJ, approximately 18 in the voting section, in addition to being senior counsel to the Associate AG for Civil Rights. From August of 2000 until the Supreme Court's decision in Shelby County versus Holder, my primary responsibility was to review changes submitted for preclearance under Section 5. I've also conducted election monitoring throughout the United States, both with and without federal observers. I began my appointment approximately 3 months prior to the 2000 election, and when the Florida recount occurred, I was shocked when I personally observed voting section staff discussing strategies, faxing, and receiving information from DNC operatives in Florida. I have also witnessed twisted racialism. When George Bush appointed Ralph Boyd, an African American, to head the Civil Rights Division, I often heard from career voting section attorneys that he's not really black and that no self-respecting black man would be a Republican. These statements and beliefs were many. I would urge every member here to read the DOJ Inspector General report on the voting section, and it provides instance after instance of bad behavior, often racially motivated among staff. It also includes abuse of an African American paralegal deemed not black enough by voting staff. The voting section has a long record of abuse by its attorneys for improper collaboration in reviewing Section 5 submissions. It's been sanctioned by courts. Between 1993 and 2000, the voting section has been sanctioned over $2 million. For example, in Johnson versus Miller, the U.S. District Court sanctioned the voting section $594,000 for collusive misconduct by DOJ attorneys with the ACLU. A federal court pronounced that the communications between those two groups, the DOJ and ACLU, were disturbing, and that the dynamics were not those of an advocate reporting to a higher authority, but rather peers working together against the jurisdiction that made the submission. After a voting section lawyer professed that she could not remember details of the relationship, the court found her professed amnesia to be less than credible. Abuse of power in the Section 5 process is not confined to Johnson versus Miller, and my written testimony provides additional instances. Section 5 was a temporary provision for a reason that no longer exists. The Supreme Court made clear in Shelby County that only certain conditions would ever justify any formula for Section 5, including blatant discrimination on a pervasive and rampant scale. Triggers that are built around political, partisan goals will not withstand constitutional scrutiny. The permanent provisions of the Voting Rights Act, such as Section 2, still prohibit discrimination and provide ample tools to challenge election procedures. Up until this past Friday, when DOJ announced that it was suing the state of Georgia, the Department of Justice has only brought 5 Section 2 cases since Shelby County was decided. Where is the rampant discrimination? Section 3 also allows a judge to have a jurisdiction submit to the preclearance provisions if it finds that the jurisdiction intentionally discriminated against minority voters. And that is consistent with the Shelby mandate that federal oversight of state and local elections be closely matched to need. H.R. 4, however, would allow a jurisdiction to be subjected to the rigors of Section 3 for violations that are not premised on intentional discrimination. Also, the new evidentiary standard for obtaining a preliminary injunction proposed in H.R. 4 sets federal law on its head. The Supreme Court has held that plaintiffs seeking a preliminary injunction must establish that they are likely to cede on the merits, and also that the injunction should not be granted when it is against the public interest. The new standard in H.R. 4 not only disregards the public interest, but it actually prohibits the court from considering any interest of the state in an application for a preliminary injunction. I'd like to thank you for your time and your attention.
Thank you, Mr. Chair. Our next witness, Mr. James Tucker, or Dr. Tucker. He's an attorney with the law firm of Elser, Edelman, in Las Vegas, Nevada. He's one of the founding members of the Native American Voting Rights Coalition, serves Rights Fund. He's chair of the Census Bureau's National Advisory on Racial and Other Populations. Served as a trial lawyer, senior trial lawyer, in fact, on the voting section of the Civil Rights Division of the U.S. Department of Justice. Been an adjunct professor at the Barrett College, William S. Boyd School of Law at UNLV. Dr. Tucker holds a Doctor of Science of Laws and Laws degrees from the University of Pennsylvania, a J. Order of the Cough from the University of Florida, a Master of Public Administration degree from the University of Oklahoma, and a Bachelor of Arts degree in Barrett's Honors College at Arizona University. Dr. Tucker, you are now recognized for 5 minutes.
Thank you, Mr. Chairman. Chairman Nadler, Chairman Cohen, Ranking Member Johnson, and committee members. Thank you for your invitation to testify on the need to enhance the Voting Rights Act. This hearing comes just 4 days after the 8-year anniversary of Shelby County versus Holder. On June 25th, 2013, in a narrow 5-4 decision, the United States Supreme Court struck down the coverage formula for Section 5, the heart of the Voting Rights Act. Shelby County's assault on the Voting Rights Act has come at a high price. In the absence of Section 5 preclearance, previously covered states and political subdivisions have turned back the clock to make the most basic first-generation barriers, obstacles that impede the ability to register to vote, to cast a ballot, and to have a ballot counted, a reality for an even greater number of Americans. Many governing bodies have increased their exploitation of racially polarized voting at the expense of existing and emerging groups of minority voters seeking equal opportunities to participate in the political process. Against this backdrop, it is appropriate that the committee has answered the clarion call to renew and restore the Voting Rights Act. H.R. 4, the John Lewis Voting Rights Advancement Act, is named in honor of one of the great champions of American democracy. Preserving the fundamental right to vote for all Americans is what brings us together in this hearing. Today, as a result of Shelby County, there is no longer any coverage under Section 4 of the VRA. Section 3C bail-in currently is the only way that a state or political subdivision can be required to submit covered voting changes for preclearance. However, the bail-in provision is sparingly used. Before Shelby County, only 18 jurisdictions bailed in under Section 3C, 2 states, Arkansas and New Mexico, 12 counties, 2 municipalities, and 2 school districts. Over half of those jurisdictions, 10, were bailed in for discrimination against American Indians. All but 2 were bailed in by consent judgments. Since 2013, only a few more political subdivisions have bailed in. Shelby County's legacy and the uncomfortable burden of finding discriminatory purpose have contributed to a reluctance by federal judges to rely upon Section 3C as a remedy to cure voting rights violations, even in the face of judicial findings of egregious wrongs. H.R. 4 makes 2 changes that directly impact bail-in. First, using a modernized formula, it restores Section 5 coverage in states and political subdivisions where it is needed most. Second, it gives federal judges the power to use the remedial authority in Section 3C where any voting discrimination against racial, ethnic, or language minority voters is established. Consonant with that discretion and their broad remedial powers, judges will continue to have the discretion to set the time frame and the scope of voting changes to which bail-in applies under Section 3C. Federal observers likewise are an important part of the Act's comprehensive framework. They prevent voting discrimination, assist the Attorney General in enforcing federal voting protections, and they measure progress with court-ordered remedies in voting rights cases. Shelby County has had a devastating impact on federal observer coverage. Prior to the Shelby County decision in 2013, a total of 153 counties and parishes in 11 states were certified by the Attorney General for federal observers. By 2020, just 5 political subdivisions in 3 states were covered for federal observers under Section 3A of the Act. 1 county in Alabama, 3 census areas in Alaska as a result of NARF's litigation there, and 1 parish in Louisiana. In the November 3rd, 2020 election, not a single federal observer was dispatched by the Justice Department and the Office of Personnel Management, which is unprecedented for coverage of presidential elections in recent decades. H.R. 4 will renew and restore the vitality of the federal observer provisions in 3 ways. It provides a new coverage formula for Section 5, which would make the covered jurisdictions eligible for certification by the Attorney General for federal observers under Section 8 of the Act. It would amend Sections 3A and 8 of the Act to allow courts and the Attorney General to certify federal observers where there has been voting discrimination on the basis of race, color, or language minority status in violation of federal law. NARF looks forward to working with members of the subcommittee in restoring the vitality of the Voting Rights Act. Thank you very much for your attention. I will welcome the opportunity to answer any questions you may have.
Thank you, Dr. Tucker. And I'll now go into our witness questioning phase, and I will proceed with the first questions for 5 minutes. First, Dr. Tucker, you mentioned how there was no observers during this past election and some changes. Was the voting rights section of the Justice Department absent without a cause during the Trump administration?
I think it's fair to say that those of us who are on the outside looking in are disappointed in terms of what the enforcement activities were under the Trump administration. One of the things that I know that Ms. Lakin alluded to, and it's certainly an issue that we've also seen with the Native American Rights Fund, is that the heft of that burden has fallen on private attorneys general, which are the civil rights organizations and private individuals and groups that have had to bring the litigation on their own. It's very expensive. Just by way of example, in Alaska, it cost us $2 million in approximately 18 months to be able to stop some language assistance, the absence of language assistance through a Section 203 case. It's very, very time consuming and expensive. And unfortunately, DOJ.
Well, I'm going to go on with my questioning, if that's all right, because we're frozen. Ms. Lakin, let me ask you this. As a lead attorney with the ACLU, was there any particular reason why there were so few actions under Section 2 in the years that Ms. Rorden pointed out? Was it because everything had gotten better and all these states stopped doing their voodoo that they've been doing for so many years? Or was it absence of actions on the government?
Thank you for your question. As Dr. Tucker has pointed out, the civil rights organizations that have been working to protect voting rights have been incredibly engaged in voting rights litigation under Section 2, under the Constitution, under other federal laws like the NVRA as well. So to the extent that the Justice Department itself was not bringing actions, I would say that doesn't characterize the state of litigation in the post-Shelby world. I think in previous testimony, Dale Ho of the ACLU has testified to the number of cases that the ACLU itself has brought under Section 2 alone, and that has certainly quite a number in the wake. As Dr. Tucker mentioned, these cases are incredibly costly, they're complex, they're time consuming. We've shouldered our fair share along with other civil rights organizations and really attempted to keep voting rights protected during this period of time, but it's simply insufficient to protect voters from losing the right to vote or being forced to vote under discriminatory regimes, and there's no way to compensate voters after the fact.
Ms. Lakin, you brought up in your testimony Purcell versus Gonzalez, the case that said kind of go real easy on injunctive relief. Probably well-intentioned, I presume it was, just as Shelby versus Holder was probably well-intentioned, but a disaster. Both were disasters for voting rights and the opportunity for people to vote. What should Congress do to address the problems that the judiciary's application of the Purcell principle has created?
Well, there are a number of things. I think a restoration or reinvigoration of the preclearance regime would certainly help in many ways because, as I've testified and many others have testified, this post-enactment relief is not sufficient. And Purcell is just one example of how that problem has gotten even worse. The preliminary injunction standard as it's being applied, this this likelihood of success of the merits which plaintiffs have to show in order to obtain preliminary relief, courts have become even more reluctant, I would say, without a very substantial showing of likelihood of success on the merits, in part because of the growth and explosion of the use of this Purcell principle as a way to almost abstain from weighing in on the merits of the case. So you have cases where courts have found a likely violation or likely constitutional violation or discrimination, and yet because it's close to the election, simply throw up their hands and say, I'm just going to let this lie for now. And that is certainly a problem. And Congress has many different ways to get involved. One would be, of course, lowering the standard for winning preliminary injunction relief. The second would also be, of course, restoring the preclearance regime, and perhaps there are other means for asking for certain fixes to the Purcell doctrine itself.
Like it. Ms. Butler, Georgia, most free, fair election in history, and yet the legislature came back and took Mr. Raffensperger's powers away from him after his heroic actions. What are some of the actions that in Senate Bill 202, which will hurt minority voting, and briefly explain those barriers to the ballot box that have been brought about by that law?
Well, first of all, it reduces the time to request absentee ballot from 90 days, 180 days down to 78 days. You now have to provide an ID, Georgia driver's license or a Georgia state issued ID. And if you don't have one of those IDs, you have to provide copies. We have a lot of rural people, a lot of elderly people that don't have access to copiers that will now have to provide copying services to get their IDs if they want to vote by absentee or vote by mail. The early voting period between the runoff, they reduced the time down to 4 weeks. That will not give you a time for a lot of our early voting during that runoff period at all. And so those are some of the kinds of barriers that we have that voters of color will be subjected to. There's broadband. A lot of people in rural areas don't have broadband access. So to get this documents to the boards of election, they will have to get it there through other means. So it's really important that we put pre-clearance back into process for these laws, because they're just putting barriers there. There was nothing about the election process. We had two audits and a recount. So it really was not fraud. And so it was a fair election, but they did implement these laws as well.
Thank you very much, Ms. Butler. I appreciate your response. Next, I recognize Mr. Johnson from Louisiana for 5 minutes.
I thank you for that, Mr. Chairman. This is an exercise in advancing a political narrative. I mentioned at the outset here, this is our third hearing on the Voting Rights Act in 3 months, because apparently the majority party thinks that this is politically advantageous. I'd love what at least one of the witnesses has said here today, bringing common sense into the equation, and I want to ask Ms. Reardon, am I pronouncing that right? What's the right pronunciation? Thank you.
It's Reardon.
One recent analyst said about H.R. 4, I'm going to quote them. They said that it would update the coverage formula by making it, quote, more onerous and almost impossible for states to defend against lawsuits against them. Likewise, opponents of the legislation believe the real aim of the act is to reverse the decision in Shelby County, which has been illustrated here today, and allow political allies at the DOJ and left-wing organizations to control state election rules in violation of the principles of federalism. I want to thank you for your expertise today, your clarity on this subject this morning. A quarter century at the DOJ in this arena is quite impressive, and you pointed out that H.R. 4 is hugely problematic. You testified the Voting Rights Act is still working today without the pre-clearance requirement, which is a dated requirement, as you pointed out. It still clearly prohibits discrimination, but you noted, and I'm very interested in this, the DOJ has only brought 5 Section 2 cases since Shelby County was handed down 8 years ago. Are they ignoring rampant acts of discrimination out there? What do you think?
I think that the rampant acts of discrimination do not exist. I can tell you that there was a comment about whether or not there were cases brought during the Trump administration. During my time period at the front office as a senior counsel, I am unaware of any request by the voting section to bring a Section 2 action that was denied by leadership.
And if I'm correct, my math is right, 8 years ago, Shelby County's handed down. Wasn't Eric Holder in charge of the DOJ during part of that time?
He was.
And he didn't bring this army of prosecutors at the DOJ out to go after this rampant discrimination, did he? I don't remember that.
No, and as a matter of fact, the amount of people that serve in the voting section has decreased since that time.
Since the 2020 election, several states have enacted or proposed election law changes. As we've noted in March, Georgia's Governor Brian Kemp signed Senate Bill 202 into law. Some of the other witnesses today are just breathless in their opposition to this. And my goodness, Ms. Butler just said it. Requiring, for example, a valid ID to vote is an unreasonable, oppressive requirement. Is that your view on voter ID as well?
No, it's not. I mean, first of all, the laws in Georgia already require an ID for in-person voting. So actually, you're treating absentee voters differently than you're treating in-person voters. So it's already been approved by the courts. I would think that in the fact that they're treating those differently probably could be an equal protection claim that someone could bring, since why should we be treating absentee voters differently than in-person voters?
Very, very well said. And last week, of course, the DOJ famously, in a press conference, filed a lawsuit against Georgia over its voting law. And I just want to know if the Department of Justice has issues with that law in Georgia. Shouldn't it also file lawsuits against Colorado and New York and other liberal-run states over their election laws, which are more restrictive than what Georgia just passed?
I would agree with that. I would also state that the majority of the provisions that they are, fighting and filed suit over are provisions that were temporary to begin with due to the COVID-19 restrictions. And so basically what they're saying is that, we put forward these provisions to make it a little bit easier for people to vote due to COVID, and now we want to keep them permanent. And so they were never meant to be permanent. They were always temporary.
Exactly right. And the chaos that ensued as a result of the 2020 election was occasioned because of all those irregularities, and it should be incumbent upon us to fix the irregularities so we don't have that chaos going forward. Despite the rhetoric you're going to hear from our colleagues across the aisle all day today, isn't it true that states are still best situated to enact changes in election law?
I think so. After all of my time in the voting section reviewing changes under Section 5 preclearance, the majority of those changes are really very, very small, very minute. And in the time period that I was there from 2000 and until Shelby County, we actually reviewed 222,000 submissions, and there were 81 objections during that time period. That is less than a third of 1% of the of the submissions that were actually issued an objection. And some of the things that I included in my written testimony, some of those objections that really were not based in fact, but based on politics, were included in those 81 objections.
I'm out of time, but I think that last phrase summarizes it. Thank you for being here today and being clear and being here in person. I yield back. Mr. Chairman, you're muted.
Thank you. I wish the staff wouldn't mute me every time. I don't need to be muted. Please don't do that. Mr. Nadler, you're recognized.
Thank you, Mr. Chairman. Mr. Tucker, as I noted in my opening statement, the number of federal observers appointments has dropped precipitously since Shelby County, and to compensate for this significant reduction, DOJ has appointed monitors instead. These monitors appear to be a poor substitute for observers because they lack the same legal authority to demand access to the voting process. What can Congress do to strengthen both the authority of the federal courts and the Attorney General to appoint observers under Sections 3A and 8 of the Voting Rights Act?
Thank you so much for that question, Mr. Chairman. As I mentioned in my written testimony, the fix for federal observers is actually very simple. There are really two that we're really talking about here. One is that we, of course, need to restore coverage under Section 5 of the Voting Rights Act. That would allow the Attorney General to certify, where it's appropriate, federal observers in those jurisdictions that are covered for Section 5 preclearance. The other is a very modest fix in Section 3A and in Section 8 of the Act that would simply ensure that the Attorney General and federal courts have the ability to appoint federal observers in places where there's a violation of any federal voting rights law that implicates vote denial for people of color or those who are of language minority groups. So it's a very, very simple fix. It's nothing radical. It's very consistent with what we've seen. And I would certainly encourage the committee to include that in the final version of H.R. 4.
Thank you, Ms. Butler. One particularly unsettling aspect of the restrictive voting laws to emerge in the states since the last election is that not only do they target or disproportionately impact minority voters, something we have unfortunately seen before, which remains a persistent problem since Shelby County, they also target election officials and administrators. Many of these election officials and administrators risked their lives to make the 2020 election a success during COVID-19 pandemic, and then they stood up for our democracy against the big lie of widespread voting fraud being pushed by the former president and his allies. How does SB 202 in Georgia target election officials, and is it your sense that certain election officials in certain counties are being singled out?
Thank you, Mr. Nadler. Yes, I do. It has, SB 202 has a provision where the legislature can take over any county boards of election, can remove any supervisor. Also, it goes hand in hand with local legislation where they can actually reconstitute the boards of elections that actually implement the laws on the local level. That has happened already in 3 counties, and we know there may be 6 other counties. We're investigating that, but it really takes the responsibility, takes total control. They remove the Secretary of State being the chair of the state election board. Again, not accountable to the voters. So it takes over total control of all of the local boards of elections, should they so desire. So it is a means to not have a voice for voters, to have their voice, and can ensure that if they're not happy with the outcome of the election, they can make sure they have the right outcome.
Thank you, Mr. Tucker. One argument that opponents of revitalizing Section 5 make is that preclearance is still available as a remedy under Section 3C of the Voting Rights Act in cases where a court finds a violation of the 14th or 15th Amendment. Did Congress ever intend, or is Section 3C designed to act as a substitute for Section 5 preclearance?
Thank you for that question, Mr. Chairman. No, Section 3C was meant to supplement, not to replace, the Section 4 coverage formula. And as I documented in my written testimony, recently the Perez versus Abbott decision shows how reluctant courts can be, even where the record is quite strong and the court has actually found discriminatory purpose, to actually apply that remedy. So no, it is meant to be complementary, not to be a replacement.
And what's the importance of that distinction?
The distinction is that it basically places Section 3C on the footing that Congress intended when it passed the Act in 1965. It's meant to be an additional measure. It's called the pocket trigger. And the reason why it's called the pocket trigger, as I noted in my testimony, Congress intended that would apply to pockets of discrimination that were not covered by the geographic coverage formula in Section 4.
Thank you. I yield back.
Thank you, Mr. Nadler. I'm going to yield the chair temporarily to Mr. Voss, the vice chair.
All right, I'm unmuted.
Okay. Thank you, Mr. Chairman. And I will now recognize Mr. McClintock for 5 minutes.
Thank you, Madam Chairman. The very nature of an election is that somebody wins and somebody loses. Democracy depends on the losing side accepting the legitimacy of the election. That's imperative, not only that an election be free from fraud, but it be free from the appearance of fraud. And we saw in this last election what happens when that appearance is abandoned. And it's been abandoned to a system where it's very difficult to purge voter rolls of people who've died or moved. We then send out ballots to all of those names on the rolls, and then we follow up those ballots with partisan workers to collect them. You know, there was a single woman in my office who received no fewer than 5 ballots at her apartment in Washington, D.C. And I got similar complaints from constituents in my district 3,000 miles away in California. There's a reason why drug tests can't be mailed in. And for that same reason, we had a system that required people to vote in person unless they were physically incapacitated from getting to the polls. And that system worked well. The process began with registration. You appeared before a deputy registrar of voters. You swore to your identity and your eligibility. It wasn't hard to find them. You could find them in every neighborhood fire station or library. Registration closed 30 days before the election, so candidates knew of who they were communicating with, and all parties could then canvass the precincts and challenge names that had moved or died. Then, on election day, and that's an important term, we called it election day because it was the day after the debate was over. We all went to our neighborhood polling place, which was usually at a neighborhood elementary school or a neighbor's garage. We looked our neighbors on the polling board in the eye as they handed us our ballot. We took that ballot into a curtained booth where nobody, not our spouse, not our kids, not our friends, nobody could pressure us, and we cast our votes according to our own consciences. We then handed that ballot back to our neighbor who put it in a locked box. Only those who were physically handicapped and could not get to the polls were afforded an absentee ballot. And at 8 p.m., we knew exactly how many votes had been cast, and usually by 10 p.m., we knew the results. These laws applied to all voters of all races, of all backgrounds, and they assured the integrity of the vote and the public's confidence in that vote. Look at how the left has changed all this. Same day or automatic registration means there's no opportunity to identify fraudulent registrations. Voters can register to vote and then cast votes without ever coming into contact with another human being. Votes are cast long before the debate's concluded. Ballots are mailed to people who've died or moved. Votes are cast under the influence of other family members or friends. Ballot harvesters can collect those ballots, meaning there's no chain of custody from the time that ballot is mailed until the time it is counted. Ballots arrive days after the election. And often we don't know the results of the election until days and sometimes weeks later. Now, Ms. Reardon, we're told that these changes are necessary because some people are incapable of following the simple process that ensured the integrity of the vote. I find that enormously condescending and downright racist. What's your view?
I've always found that the statement that any particular minority group is less likely or unable to follow the statute's provisions in each state to be very racist.
How have these changes, recent changes in our election laws, affected public confidence in our elections?
As someone who looked at the 2020 election, I think based upon the number of changes in states that really basically did away with many of the election integrity provisions based upon the allegation that it was necessary for COVID. I think what you saw across the nation, people recognizing that the normal types of statutes that were in place requiring signature matching or identification or having your ballot mailed in by a particular day, I think people looked at that and saw that it was more likely that fraud would occur under those circumstances.
And doesn't every fraudulent vote invalidate a legitimate vote?
Yes, sir.
And isn't that the ultimate voter suppression?
I would agree with that statement.
Thank you. I yield back.
Mr. Raskin, you're recognized for 5 minutes. You're muted.
Ms. Butler, I'd like to come to you if I might. I heard one of our colleagues say somebody wins and somebody loses in every election. I wish they would tell that to Donald Trump. America would be a lot better off if he accepted that. But we seem to have two rival theories about what's going on in Georgia today. The way I see it is every time that there's been an advance in people's voting rights in American history, there's been a backlash against it. So after the Civil War, fought to free hundreds of thousands of enslaved people and to give them the right to vote and to bring them up in the Reconstruction process, there was a reaction against that, and we saw all kinds of voting restrictions. Some of it was just violence and terror, but some of it was grandfather clauses, literacy tests, poll taxes, character tests, and so on. And these laws were instituted in order to secure the purity of the ballot, which essentially meant keeping Black people from voting. And we've seen these constant efforts to undermine voting rights of African Americans in our history. And it seems pretty clear to me that what's going on in Georgia is all about the fact that Georgia just elected its first African American senator in history, Senator Warnock, that Joe Biden was the first Democratic candidate to win there in decades. That's certainly what is going on if you ask anybody on the ground in Georgia. And yet there's this rival theory out there, which is it's really about fraud, corruption, chaos, back to that old cover story for racism. And I'm wondering if you can help us sort this out, because I don't live in Georgia and I haven't been there in a long time, but I do know there were 62 lawsuits brought by Donald Trump and his supporters alleging corruption, fraud, and chaos in the 2020 election, and they were all rejected in the lowest courts in the land, circuit courts and district courts and the state level and the county courts, all the way up to the United States Supreme Court. They all rejected exactly the kind of stuff we're hearing today about how there's some impurity of the ballot, some assault on the integrity of the ballot. And then I hear people actually accusing, if I'm understanding them right, the civil rights forces of racism because they are opposing efforts to restrict the ballot. So would you help us sort this out? I mean, is my sense right that this is just the conventional racist backlash against Black people voting? Or is there some fraud out there that no court in the land could find that's been completely rejected? I think that even Attorney General Barr described Donald Trump's claims about voter fraud as BS. And I'm being polite there, I'm not spelling it out. So let me turn it over to you, Ms. Butler.
Thank you. No, there hasn't been any fraud in Georgia. We had 3 hand counts of the ballots in Georgia. That means all 159 counties did an audit and they did 2 recounts, hand recounts, not using equipment, but they did hand counting. We had the GBI and the FBI look at our signature match process. It was found competent. There was nothing that they found wrong with it. There was no fraud. We had an exceeding number of people turn out to vote because in this pandemic with COVID, they were able to exercise that right to vote, and they did that. And because of that, we now have these egregious laws that will take over local boards of election, take total control. When I'm on the board of election, I was on a board of election, we were responsible for counting the absentee ballots. We were responsible for making sure that the ballots were rejected or accepted. We were responsible for accepting provisional ballots, making sure the proper documentation was received. So with the entire process, to the poll workers being trained, we were responsible.
Can I interrupt you for 1 second?
Smoothest election. There was no fraud.
I want to get one other point in here. I know that during the election, or right after it was over, former President Trump called the then Secretary of State, Brad Raffensperger, who's a Republican, and said, just find me 11,781 votes. He was trying to encourage him to commit election fraud, voter fraud. Is there anything in the legislation that the Republicans are passing that would stop Donald Trump from trying to implant false votes in Georgia? Responded to that at all?
The witness will answer very briefly because the gentleman's time's expired.
No, the law does not address that issue at all. It stops legitimate people from exercising their right to vote.
Thank you very much. I yield back, Madam Chair.
Mr. Roy is recognized for 5 minutes.
I thank the gentlelady. Mrs. Reardon, when the United States Supreme Court struck down Section 5, they did so, best of my understanding and recollection, in significant part because it was based on, at that time, 40-year-old data, and that it was based on information from 1968, 1972, and it was particularly dated. And in particular, that the record that was put into the record in 2006, when VRA was reauthorized at the time, was replete with examples where there were covered jurisdictions that had certain issues that were being raised, and then non-covered jurisdictions, but there was no real correlation, and that was part of the problem. Is that roughly correct from your recollection of the case?
Yes, it's definitely that there seemed to be no legitimate basis to have certain states covered at that particular time. And I think also the Supreme Court was very clear, and what they said was it was always supposed to be a temporary provision because they understood in the 1960s that there was, it was necessary to have Section 5, but that in the 2000s, it's no longer necessary.
Ms. Reardon, do you think the Department of Justice is particularly objective in the way that it would carry out preclearance? And just a simple answer on that one, and then I have to follow up.
I do not.
Are you familiar with the Department of Justice Inspector General report from 2013?
I am.
Are you aware that Chapter 4, Part 3 of the report, page 135, highlights that disclosures and other confidential information was leaked to reporters, likely by voting section employees?
Yes, that would happen on a regular basis.
And what kind of information was leaked? Can you provide examples, keeping in mind we're on the clock, but a few examples for the committee?
I think during the, I want to say the Georgia voting ID case, there were individuals who leaked information from the inner workings of the group that was responsible for reviewing that particular submission. I can think of that. I know that there were a couple of, actually one particular attorney that claimed that she was the basis for one of the books that was written about the DOJ. Those are just two examples.
Are you aware of the report highlighting that analysts lied under oath?
I am.
And do you have any background or examples of that?
I know that during the Inspector General report that there was a civil rights analyst that was specifically asked a question by the attorneys that were doing the investigation, and that she lied under oath.
The report provides examples of non-attorney voting section employees, posting comments to websites concerning voting section personnel or matters. One example describes an employee who started a, quote, cyber gang, unquote, that was engaged in, quote, cyberbullying, end quote. According to the report, he told the OIG that for his internet postings, he selected as his alias the name of the protagonist of a well-known novel because he represented the archetype angry black guy, end quote, page 129 of the report. Are these the same people that would be doing pre-clearances of election law changes under H.R. 4?
Yeah, there are some of those same people there.
Is that troubling to you?
Yes, I mean, one of the things that I found to be so shocking while working in the voting section was the fact that it was so political. I just think that a section that is termed voting, that is supposed to review voting changes in the Civil Rights Division, should be nonpartisan. It is the furthest thing from nonpartisan.
I apologize for being a little bit late. I had a conflict, but I suppose there's been some conversations here about H.R. 1 and S1 and about some of the issues involved with those pieces of legislation. Obviously, right now, having hit a wall in the Senate, do you believe that H.R. 4 is trying to be used as a backdoor to try to get the federal takeover of elections carried out in the absence of being able to currently get that executed on the Democratic side of the aisle?
I do. I think that this particular bill is looking to reauthorize a provision of the Voting Rights Act that is no longer necessary because there is no rampant discrimination in voting. One of the things that I said earlier was the fact that during the time period that I was there, from 2000 until 2013, there were 222,000 submissions that were submitted by local jurisdictions. I would say that 98% of those submissions really concern moving a polling place within the same building. There is just not rampant voting discrimination between 2000 and 2013. There certainly isn't today.
When my colleagues on the other side of the aisle say that, quote, the Voting Rights Act has basically been turned over or overturned by the court. That's not true, is it, right? We're talking about Section 5. The Voting Rights Act remains firmly in place, protects the rights of American people to vote. But rather what we're doing is allowing states to continue to be able to figure out the laws and place voting booths where they need to be and so forth. Would you agree with that?
I would.
Thank you, ma'am. Yield back.
Thank you, Ms. Ross, for taking the chair. Take the chair and recognize you for your 5 minutes of questioning.
Thank you, Mr. Chairman. As a civil rights attorney and former state representative, I've witnessed firsthand the incursion on voting rights in North Carolina and fought against them. In 2011, the North Carolina General Assembly completed redistricting that relied on racial gerrymandering. These newly drawn maps were ultimately struck down by the United States Supreme Court, and in 2017 in Cooper versus Harris. However, numerous elections occurred during the intervening years. Those who were elected because of the unconstitutional maps went on to incur incumbent advantage, and in some case, work against the interests of those who were disenfranchised. I was there in the North Carolina General Assembly in 2011 when that redistricting occurred. In 2013, North Carolina enacted a restrictive voter ID law, which the Fourth Circuit noted targeted African Americans with almost surgical precision. The very forms of identification prohibited by this law were those disproportionately held by African Americans, and the bill eliminated a week of early voting, a period which African Americans utilized the most. Once again, the courts righted the wrongs of the state legislature, but it took nearly 3 years for the litigation to reach its conclusion. During that period, nearly 200 officials were elected, including a U.S. Senator, 13 members of Congress, and 4 North Carolina Supreme Court justices. These cases in North Carolina demonstrate that Section 2 litigation by itself is not sufficient to protect voting rights. We need to stop voter suppression before it happens, not years afterward. Disenfranchised Americans cannot wait years for their rights to be restored and uncompensated. It is not possible for voters to truly receive a remedy on the back end. Efforts to undermine our core American values should never be allowed to take effect. My first question is for Ms. Lakin on the Purcell principle. In your view, did the Supreme Court intend to create this elaborate new voting rights doctrine when it issued its unsigned opinion in Purcell versus Gonzalez in 2006?
No, I don't believe that's the case. If you look at the very brief unsigned opinion, as you note, it is mostly a decision about deference to a lower court's discretion. And only in passing does it raise a very common sense warning that you should consider specific considerations that are come up in elections when you are balancing the equities in that case. That is, whether or not the injunction is in the public interest and would not cause irreparable harm. It has grown and metastasized well beyond that brief decision and reference in that case.
Thank you very much. And Mr. Tucker, courts have interpreted Section 3C to require plaintiffs to prove purposeful discrimination to invoke preclearance as a remedy. Mr. Nadler asked you some questions about this. This is an already high evidentiary bar for plaintiffs to meet, but you note in your testimony that courts have also been reluctant to reach the question of whether the plaintiffs have established intentional discrimination once the plaintiffs have already established discriminatory impact. What accounts for this judicial reluctance?
Thank you so much for the question. It actually highlights the same issue that Congress actually visited in 1982 in the 1982 amendments. Following the City of Mobile versus Bolden decision, that's precisely what we saw with Section 2 cases, that there was a reluctance if Section 2 was going to be construed in the same manner as the 15th Amendment, that judges are frankly hesitant to call their neighbors, to call their friends, to call election officials that they may have dinner with racist. And that's the fundamental problem. And so what Congress has proposed in H.R. 4 is a very modest change that would simply recognize that where voting discrimination has occurred in whatever form, that discrimination should also be subject to Section 3C preclearance, as the court may find limited under whatever circumstances and for whatever time period.
Thank you very much, Mr. Chairman. I yield back.
Thank you. And I think Ms. Fishback is next for 5 minutes.
Thank you, Mr. Chair. Ms. Reardon, I do thank you for being here in person today. I appreciate that. And as Mr. Johnson had mentioned earlier, that we've had several hearings on this topic. And but to my understanding, the only thing that's really changed since we've had those hearings is that the Attorney General is launching the suit against the state of Georgia over SB 202. And I was just wondering if you could maybe comment on if the Biden administration wins that lawsuit, what the effect is going to be on the elections being conducted in Georgia.
If the Biden administration is successful in the Section 2 matter, what will happen is one of the things that they're asking for is they're asking for the state of Georgia, of course, to be covered under Section 3C. So every single voting change in the state of Georgia will need to be submitted to the Department of Justice for preclearance. And they're also asking for a preliminary injunction against the changes. So if they are successful, none of SB 202 will move forward. In addition, they're asking for federal observers to be placed there. But in the end game, if they are successful in showing that SB 202 was instituted with a discriminatory purpose, which is what they are arguing, then SB 202 will not be able to go forward. It will be declared unconstitutional.
Thank you. And what it sounds like to me is a real invasion of the federal government into state elections. But and what implications? What would the implications be if H.R. 4 on stage, which are attempting to answer waning faith in elections by strengthening election integrity? What would the effect of the implications of H.R. 4?
I think H.R. 4, when utilized by the Department of Justice, will probably put the kibosh on any state moving forward with election integrity provisions. There is a general thought within the section itself that there is no need for election integrity laws. Additionally, based upon the reauthorization of Section 5 in 2006, it is not only whether or not an election mechanism has a purpose, a discriminatory purpose, it's also whether or not there's any effect on minority voters. So what often happens is you get into a situation where, let's say, there is a voter identification requirement that is submitted for preclearance, and that 88% of white voters have that particular ID, but 86.9% of African American voters have that ID. That particular change will be objected to by the Attorney General. So it really comes down to a percentage game within the department.
Thank you very much. And what do you think about the constitutionality of H.R. 4? And are there areas that you would question the constitutionality of?
I would question the initial reauthorization of Section 5's constitutionality for the simple reason that if anyone reads the decision in Shelby County versus Holder, they clearly stated in that case that in order for the federal government to exert that type of control again that they were given under Section 5, that there would have to be rampant discrimination against minority voters. And based upon my experience enforcing these laws for 20 years, that's just not the way that I think the evidence comes in. I also think that changing the standard for a preliminary injunction that demands that a court ignore a state's purpose for making those laws is unconstitutional as well.
Thank you very much. I appreciate it, and I yield back my 49 seconds.
Thank you, Ms. Fishbach. I appreciate that. Uh, Mr. Johnson, you're recognized for 5 minutes.
Thank you, Mr. Chairman, for holding this very important hearing. Ms. Butler, you previously served as a member of the board of the Morgan County Board of Elections. Is that correct?
That's correct.
And when were you first appointed to serve?
I was appointed in 2010.
And you served all the way up until what point?
I served until just recently, June the 30th was my last day as a Board of Election member.
And why was that your last day of service?
The board was reconstituted, as I had previously stated, through local legislation. It was reconstituted at the request of our majority Republican county commission under the guise that our board was dysfunctional. What that meant, I don't know.
Well, let me ask you this now. When you were first appointed to the Board of Elections of Morgan County back in 2010, how were you first appointed?
I was appointed by the Democratic Party. There were 2 appointments by the Republican Party, 2 by the Democratic Party, and 1 by the County Commission.
And so it was pretty much was it and let me ask you about Morgan County now. Morgan County is a county where there are roughly 72.7% white and 23.6% black. Is that correct?
That's correct.
And back in the 2020 election, about 28.6% of the voters voted Democratic. Is that correct?
That's correct also.
And so you were previously appointed to serve on the Board of Elections by the Democratic Party, which elected 2 Democrats, and the Republicans had 2 seats that they controlled. And then the county commission appointed 1 person. That person was nonpartisan.
Correct.
And so you had pretty much a nonpartisan board. But now with Senate Bill 202 having become law, it included a provision that was inserted by your local legislator that changed the way that the Board of Elections members were chosen, correct?
That's correct. They're now chosen.
The change was that instead of the process that I just explained and you just explained, now it's the county commission that appoints all 5 members to the local Board of Elections, correct?
That's correct.
Now, your county commission is, how many members on the county commission of Morgan County?
There are 5 members of the county commission.
And how many of those members are Republican?
4.
So you have a 4-to-1 Republican majority on the Board of Commission that will now select the Board of Elections members. Is that correct?
That's correct.
And they failed to replace you when your term expired. Have they appointed anyone else to fill your position?
They've appointed all 5 members. They are 4 whites and 1 black. Our previous board was 3 whites and 2 black.
Okay, and do you know the composition of the board now, the Board of Election? Is it 4 Republicans and 1 Democrat?
I don't know their political affiliations, but predominantly, I would say, yes, they are predominantly Republican.
Well, now, you know, so as as one of your roles as a Board of Election member, you all determined where drop boxes would be situated around the county. And you counted up the absentee ballots and provisional votes. What do you think is going to happen to that now? Will it become politicized in favor of the Republicans as a result of this new change brought about by Senate Bill 202?
Well, the drop boxes are now limited, and basically they are to be inside and will not serve the purpose for which they were originally placed, to make it easier for people to use them without having to come in contact with anyone, and they could do them at all different hours of the day.
But all of that has been cut out by Senate Bill 202, which requires that the drop boxes be in the early voting locations, which are determined by the Board of Elections. Isn't that correct?
That's correct.
Okay, with that, Mr. Chairman, I yield back. My time has expired.
Thank you. Now I'd like to recognize Mr. Owen, Utah, for 5 minutes.
Thank you, Chairman Cohen and Ranking Member Johnson and witnesses. Thank you for holding this hearing and for your participation today. The Voting Rights Act passed in 1965 is a critical piece of legislation that prohibits racial discrimination in voting. 2 months ago, I was asked to participate in a Senate Judiciary hearing titled Jim Crow 2021, the latest assault on the right to vote. As I stated at the hearing, I grew up in the Deep South during the era of actual Jim Crow that actually suppressed voting. The Voting Rights Act effectively ended Jim Crow laws and enforces the 14th and 15th Amendments to the United States Constitution. In the United States of America, a person is guaranteed equal protection under the law and equal access to vote, regardless of his or her skin color. However, at the Senate hearing and still today, I was offended to hear the comparison between Jim Crow laws and the recently passed voter reform laws in Georgia. I'm going to focus my remarks today on the one area of alleged voter suppression, the uproar over the requirements that voters produce a federal ID. Unfortunately, today we've heard the same message that we heard earlier this year, that Americans, especially lower income and minority Americans, particularly Black, aren't capable of following laws and rules to vote in federal elections. In fact, the section of SB 202, the recent passed Georgia law, states that has brought such an outrage from the left simply because it requires any person applying for an absentee ballot to include evidence of a government-issued ID on the application. If a voter does not have a driver's license or ID card, that voter can use a current utility bill, bank statement, government check, paycheck, or other government documents that show the name and address of that voter. And by the way, 97% of the Georgia voters already have government-issued IDs. The Georgia law, SB 202, includes many positive changes to the state voting laws. For example, SB 202 would expand the state's early voting period. It codifies the use of ballot drop boxes. It reduces precinct wait times. This is not voter suppression, as was seen before in the Voters' Right Act passed. And yet President Biden's Justice Department has sued Georgia over SB 202 because it allegedly discriminates against Black voters in violation to the Voters' Rights Act. I am bothered by statements that poor Black Americans lack the common sense, education, tenacity, and desire to succeed. This is the very definition of a condescending bigotry. For those who continue this line of thought, I have questions. Do Italians, Polish, Jewish, Swedish Americans also have this problem of finding it impossible to get an ID? And by the way, it is impossible to succeed in this country, to get a job, education, bank account, travel, even get a welfare check without a federal ID. My observation, this condescending uproar from the left is not about fair voting. It's not about representing the hopes and dreams of poor Black Americans in these urban communities who simply want, like every other American, to succeed. It's about power. Every representative who still has a mass number of constituents in their district who want IDs and have no idea how to get it should be ashamed of themselves. They are failing their constituents on the bare basic of representation. In my most humble opinion, putting together a team to help constituents get an ID to grab hold of the first rung of the ladder of success is not a heavy lift. Lack to help their constituents, waiting instead for big brother federal government to do so is absolute and total negligence. The bottom line is Republicans want every legal vote to count, want to make it easier to vote and harder to cheat. And yet Democrats have generally opposed these election integrity measures. We must do better. Ms. Rodan, I'm sorry. The Constitution leaves it to the states to administer election within their jurisdiction. Are states best situated to determine how to run their elections?
I believe that the states are best. They are the ones that know what's going on the ground. They are aware of who their constituents are, and they are the ones that are directly represented and elected by their citizens in each state.
There's another common misconception that the new law bans prohibiting drinking water to voters while waiting in line. In reality, this law does not do this, correct?
That's correct.
Okay, the law actually bans electioneering by prohibiting non-poll workers from distributing food and water to waiting voters. However, this is a carve-out that allows poll workers to make available self-service water to those waiting in lines. Is this also your understanding of the law?
Yes, it is. As a matter of fact, we would actually witness very often on the Navajo Indian reservations when we would do election observation coverage that that was a real issue there, that very often the Democrat Party and the Republican Party actually have barbecues, serving food, et cetera, outside of the polling place. There really is no place for that outside of a polling place. We have limitations on where you should be in regards to where people are voting when you are part of a party representing a candidate, and that is what the law is designed to frustrate.
Ms. Rodan, I'm going to run out of time. Thank you again for your clarity, and I yield back.
Thank you. And next, I'll recognize the lady from Houston, Texas, with experience on the bench, Ms. Garcia.
Thank you, Mr. Chairman, and thank you for this opportunity to once again have a full discussion on the Voting Rights Act. Unlike my colleague, the ranking member, who complains that this is the third time in 3 months, I wish we would have even more because this is really a very important topic, not just for those of us in Texas, but for all Americans to ensure the voting rights of all Americans. So I wanted to start first with also quoting the ranking member. He said the goal of is to have a fair and free and secure elections. In my judgment, I think we had a fair, free, and secure election last time. Ms. Lincoln, do you agree? Have we had a fair and free and secure election?
Thank you for that question. Democracy is strongest when more of us can participate, not less. And the turnout that we saw in this past election and people turning out and voting in record numbers really does support that our democracy is strong. And as far as we can tell, all evidence points to that this past election was held in a free and fair manner.
Well, thank you. Mr. Tucker, do you agree? I would take a yes or no in the interest of time.
Yes, I agree completely.
Well, thank you. Ms. Butler? A yes or no in the interest of time?
Yes.
Well, thank you. But yet we continue to see the Republican-led state legislatures across the country seek to restrict voting rights based on the erroneous and unfounded claim of voter fraud. So this, in fact, is a now or never moment for American democracy. While I'm proud of my House colleagues and the work that we've done in passing H.R. 1, we must continue to fight hard today, every day, until we make sure that it passes in the Senate. Voters across the country elected established Democratic majorities in both chambers of Congress and delivered a unified government because we vowed to protect democracy. Put simply, this is about ensuring all Americans and all Texans that to have and exercise their right to vote regardless of their race, ethnicity, gender, income eligibility, party affiliation, or language. But while the Senate has not voted for the people, our governor has continued to do and enact voter suppression laws, and in fact has called a special session to continue on his strategy of doing that in Texas. So lastly, I commend the Justice Department for recently announcing that they have filed suit against Georgia. It needed to be done, and I'm glad they did it, Ms. Butler, to support the work that you and many have done to ensure that all people in Georgia have a right to vote. But it is much like the fight for us here in Texas, where Latinos are often too burdened by many of the restrictions imposed by our governor and his Republican allies, including barriers to an interpreter and barriers for assistance at the voting booth. In light of these attacks, we must continue. Our Texas congressional delegation has sent letters both to the Justice Department and to Senator Schumer about needing and urging the passage of For the People Act. So, Mr. Chairman, I have for the record and ask for unanimous consent to put in the record a letter from the Texas delegation to the Attorney General Garland urging him to protect the Voting Rights Act. Also a letter from the Texas congressional delegation to Majority Leader Schumer expecting urgent need to preserve every Texas right to vote. Additionally, in my written testimony in June of 2014 to the Senate Judiciary Committee on updating the Voting Rights Act in response to the Shelby decision. And number 4, an article on the Justice Department suing Georgia over voting restrictions. I ask for unanimous consent.
Without objections, such should be done.
Oh, great. And Ms. Lincoln, I have a question for you. I've been concerned, particularly every election. I represent a 77% Latino district. We get complaints daily as the election starts, even in early voting, about the difficulties Spanish-speaking voters have in getting an interpreter to be able to interpret anything at the polls, bringing any friends to help them and assistance to vote, or even bringing in their own interpreter to vote. What can we do under Section 203 to ensure that any American with a language barrier has full access to registering to vote and exercising their right to vote at the ballot?
Thank you for your question. The voter protections in 203 itself that provides that voters who seek assistance in order to be able to vote, with very limited exceptions, should have that opportunity. That should be enforced and respected for voters.
Well, they don't, especially here in Texas. And my question was, what else can we be doing under that section or any other section of the Voting Rights Act to make sure that everyone has the access to the ballot? I can tell you that as a senator in Texas, I had a bill to ensure the right to interpreter, and I couldn't even get it out of committee. And so it is happening. It's real. It happens every election here in Texas.
I think the assistance of federal observers, and I would pass it to Dr. Tucker to make sure that these provisions are being enforced, would go a long way.
Mr. Tucker?
I would just add that Section
Gentlelady's out of
208
time.
already guarantees that
We are over
individuals have
time. We're over time, and we've got to yield back to the next speaker. We're a minute over.
Mr. Chairman, could I just ask them that he submit his response in writing for the record?
Sure. Please.
Thank you. Thank you,
Thank you.
Mr. Tucker.
Thank you. And next, we'll recognize Mr. Corey Bush from the great the great city of St. Louis.
Yes, the great city of St. Louis. And St. Louis, and I thank you, Chairman Cohen, for convening this hearing and acknowledging St. Louis. Thank you. To all of my colleagues here today and elsewhere, we are running out of time. Just in the last few weeks alone, some of our colleagues in the Senate have actively been undermining our ability to deliver significant voting reforms. I want to focus my remarks today on nonpartisan federal election observers. We all watched as Georgia passed SB 202 with a provision that makes it a crime punishable by up to a year in jail for nonpartisan volunteers to provide bottled waters for voters in line outside of polling places. That's what we're up against. Several Republican-controlled states have gone out of their way time and time again to suppress Black voters because they fear our power and our political vision for America. They know what we stand for. That's justice and our liberation in its totality. Some of my colleagues can sit here and use coded language about states' rights in the federal government, or we can call it what it is. This is a conversation about one party's intent and their ongoing white supremacist attempts to suppress the power of Black and Brown, Indigenous, and other marginalized voters. Missouri, Georgia, my state of Missouri, Georgia, Texas, Arizona, the list goes on. Each of these states have introduced and passed restrictive voter laws. They will continue to do this without this type of oversight. It is for this reason that nonpartisan federal election observers are needed to investigate, document, and build a record of discrimination that can be used in courts and to inform legislation. These nonpartisan observers strengthen our election process by providing information and oversight when poll workers and administrators are often and otherwise overstretched and overworked. In 2016, federal election observers were only sent to 5 states during our presidential election. This was one of the smallest deployments of federal observers since the 1965 Voting Rights Act. Scaling back observers makes it difficult to detect and counter efforts to intimidate voters, meaning we don't even know how bad it is in many states across the country. So, Mr. Tucker, how do federal observers play an important role in enforcing the Voting Rights Act, and how has their role been diminished? I'm sorry. How has it been diminished since the Supreme Court's decision in Shelby County?
Thank you so much for that question. As I noted in my testimony, I think the easiest way to think of federal observers is with the acronym PEP. I mean, a lot of us attorneys, that's how we remember cases. It stands for Progress in Enforcement and Preventing. Basically, they prevent discrimination from occurring. They make voters feel more comfortable. People are less likely, if they have people watching, they're less likely to discriminate against minority voters. They enforce because where they document instances in which violations of the 14th or 15th Amendment or the VRA have occurred, the DOJ has that information that they can prosecute it criminally if necessary. And then they also measure progress, because that's really important. Many of the jurisdictions are covered under federal court orders, and it helps the federal judge assess how are they doing. Are they actually coming into compliance with the terms of the order? Shelby County's impact has been twofold. One is that, as I noted, by eliminating the Section 4 coverage formula for Section 5, it essentially eliminated the mechanism by which the Attorney General can certify jurisdictions for observers. And then the second thing, as I also noted, is that federal courts are reluctant to find intentional or purposeful discrimination, which has limited the scope of Section 3A relief.
Thank you. Ms. Butler, how have polling site closures disproportionately impacted Black, Brown, and Indigenous voters?
Well, I tell you, most of the polling location changes in Georgia, and there have been over 200 or so since the Shelby decision, they are predominantly in African-American communities. And so that's how it has impacted it. It's made them so that they consolidate them. People have to drive further in rural areas without public transportation. Everyone doesn't drive. So it makes it difficult. It's just a barrier for people to be able to exercise their right to vote freely.
Yes, and our right to vote is the foundation of our democracy. The right to vote is our instrument for change. Who we choose to represent us is a reflection of our struggles and our aspirations as a country and a society. It angers me that this fundamental right is often suppressed in this functioning democracy. Thank you, and I yield back.
Thank you, Ms. Bush. And now I recognize from Houston, Texas, where they not only sing, but they dance, Archie Brells and Sheila Jackson Lee.
Mr. Chairman, thank you for your generosity, and thank you for this hearing. A statement of fact that seems to have eluded my great friends on the other side of the aisle. The Supreme Court case decided by the conservative court, the Shelby case, which I decision that did not needed to be rendered in a skewed manner in which it did, completely exploded the plea clearance provision that provided the opportunities of freedom, emancipation, voting for African-American voters and other voters. Let me be very clear. The very existence of my district and others were because of the 1965 voting rights law. The very existence of my current 18th congressional district is because of the 1965 Voting Rights Act and its modifications and reauthorization mid-2000s. So any commentary about poor voters or African-American voters not able to get ID cards and incredulous thinking about why are we having these hearings. We're having these hearings because the Supreme Court instructed us to have hearings so that we can fix and redo and put back in place a vital lifeline for American voters of all kinds to have an equal right to vote, and that is clearance 5. Now, let me compare both the 4 years of the Trump administration, where they barely opened the door of the Civil Rights Division and offered 3-week Section 2 cases, compared to the Obama starting in 2013 that did major voting rights cases under Section 2, the North Carolina case that brought fairness to those in North Carolina, as my colleague said, 2 Texas cases that involve state constitutional redistricting and the voter ID. In fact, my case, my district right now is in the court. It is a voter case or voter ID district. I am at the mercy of the Voting Rights Act again to do districting in Texas. Let my colleagues know, and I have said it on the record today, this stage, 29th, 2021. We'll have to fight to make sure that the district of Texas is fair so that the districts are not stolen, because the basis of the growth of Texas is based on minority African and history. So I lay the groundwork for my question. This is an outrage to even be suggesting that we do not need that I think is important. Shelby, the justification released upon the conservative majority, the justification relied upon by the conservative majority of the Supreme Court to strike down Section 4 of the Voting Rights Act today essentially comes down in this time change. Chief Justice is right. Times have changed. What he neglected to add is that the reason why the times changed. So my question to you, Ms. Lincoln, is explain why Section 2 is not an adequate substitute for vigorous Section 5 preclearance. My time is running because of the predicate that I laid, but I'd appreciate it. I have another question.
Or just quickly, it's incredibly expensive, costly, complex, and time-consuming to bring Section 2 litigation. As a result, elections can take place and hundreds of elected officials and millions of votes can be cast under regimes that courts later find are discriminatory. There's no way to compensate voters who have suffered from this discrimination after the fact. There's no way to rerun those elections. So Section 2 is simply it's important and it's a vital tool for voting rights advocates, but it's not sufficient.
The damage was already done with the voting ID law when we had to come in on a Section 2 in Texas. Thank you so very much. But let me just publicly apologize to you for having given such one service and then having your position viewed by a that looks to me that there was imbalance between the ultimate person selected. It was based on party. So give me your sense of what would have been helpful to you if there was a clearance as they would be for voting mission that you Butler?
Well, pre-clearance, of course, would have made sure that any of these changes would have gone through DOJ's pre-clearance process. And I do believe they wouldn't have gone through. We've had to expend a lot of our time as being plaintiffs in lawsuits for exact match, for polling location changes. And these types of changes wouldn't have occurred if Section 5 of the Voting Rights Act was operable. We wouldn't have experienced this, I do believe, and it was strictly, from what I can determine right now, based on our objections to barriers to the voting process.
Thank you, Mr. Tucker. So many of my voters stated because senior citizens, they're people of color, they're bilingual, they're barrier issues, but they have the right to vote. What is the special emphasis of federal observers, how important those are? Mr. Tucker?
Yes, so observers, as I mentioned, ensure that Voters are able to exercise their ballot freely, free of discrimination, free of intimidation. They're able to enter the polling place. If they need assistance, they document that. If it's not given, they document that as well. They basically are the eyes and ears for the Attorney General, for federal courts, and for private attorneys general that are trying to enforce the guarantees of the 14th and 15th Amendments.
Thank you, Mr. Chairman. I want to submit into the record the following, if I could. Houston Chronicle, Governor Abbott limits mail ballot drop-off locations. NBC News, racist voter suppression. Texas Tribune, it's harder to vote in Texas. And a strong Voting Rights Act is needed now more than ever in the Hill, dated June 26, 2021 op-ed. I ask unanimous consent to submit these in the record, Mr. Chairman. Thank you. And that's why we're going to write a strong Voting Enhancement Act committee.
It will be admitted into the record. We
Thank
appreciate
you.
it. That concludes today's hearing. It was an excellent hearing. We should have probably just discussed the big lie, and that's the reason why everything's changed with the voting laws and with the need to have monitors and everything else that we haven't had since in the past when we had President Bush, a president in the tradition of presidents. Instead, we had the big lie, which Bill Barr called total BS. Thank you, all of our witnesses for appearing today. Without objection, all members will have 5 legislative days to submit additional written questions for the witness or additional materials for the record. The hearing is adjourned. Thank you.